Hello guys, American Amy here. I have a very interesting, I guess it's a committee in front of, I guess these would be like representatives or something. I'm not quite sure. But they're holding a special hearing about DCYF. And I think it's very interesting, and I'm going to leave the link to this channel. Everything this guy spoke in this video was according to the Constitution and Black Laws Dictionary. I think this is a wonderful, wonderful speech by one of the people on behalf of all of us, and definitely not only for the Constitution, but for the children that are being taken without a trial. You know, you can't take somebody's property without a trial, but you can take their offspring. That's not fair. And anyway, I'm going to give you the link to this channel. And he said, ready to learn how to fix a constitutional republic? Because in case you didn't know it, we do not live in a democrat. This is not a democracy. This is a republic. There's a difference. If you don't understand it, you need to read it. And then he's got some other channels he's recommending and stuff. So I'm going to definitely leave the link. This is a great piece of information here, and let's record the video.
Up to speak, we have Andrew Noyes from Bethlehem. Andrew Noyes. Noyes. Thank you, sir. Raise your right hand. Do you swear the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Thank you, Representative Cushman. I find it interesting that the discussion here started about oaths, concerning oaths. We're hearing a lot of issues here about a lack of truthfulness, lack of oversight, lack of accountability, and everything I'm about to present here concerning due process, all really kind of goes back to that. And I think that it's really important that we remember that DCYF and the legislators that are involved with the oversight of DCYF all swear oaths to the state constitution. So with that, due process. The Bill of Rights in Article 14 and Article 15 reserve back to the people the right to remedy, a swift remedy without denial. It's supposed to be prompt and without delay. Again, that's something that we're not really hearing in testimony here. And Representative Cushman, thank you for responding to the will of the people and their lawful instructions to look into this matter. And of course, you have the notices and affidavits from the people who are willing to hold an account to what they have seen, what they see in the lack of due process here. In Article 15, the Constitution says that no subject shall be arrested, imprisoned, despoiled, or deprived of his property, immunities, or privileges, put out of the protection of the law, exiled, or deprived of his life, liberty, or estate, but by the judgment of his peers, or the law of the land. It's a maxim of law that no free man shall be deprived of life, liberty, or property, but by the lawful judgment of his peers, or by the law of the land, that is, the common law. Black's Law fourth definition of the law of the land is due process of law. And so it's really interesting here as you start to look into the founding generation's understanding of what due process is and how that is going to correlate to this term law of the land, and the constitutional view, which everybody understands here, is your main prerogative, and everything else is going to follow out of and flow out of your constitutional obligations. That these two terms really go hand in hand. So due process of law, by law of the land, is most clearly intended, again, this is from Black's Law, intended the general law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. Black's Law fifth definition of common law action is an action governed by common law rather than statutory, equitable, or civil law. So I want to pause there for a second. There's a lot of discussion around the statutes which may have been violated concerning a parent's right to due process. The parent's rights, as are secured in the Constitution, are common law rights, rights which have been understood in antiquity and were very well understood amongst the founding generation to exist regardless of statutory law, and in fact are secured against any infringement by statute. That's very, very important here as we're looking into the process, into due process, and something that it's imperative that you really stress that and look into whether any statute which may be enacted or has been enacted already can deprive a parent of their rights. And interestingly, in part 2, discussing form of writs, Article 87, where it says all writs issuing out of the clerk's office and any of the courts of law, Black's Law defines court of law as, in a narrower sense, a court proceeding according to the course of common law, governed by its rules and principles, as contrasted with a court of equity. So just really wanting to nail down here, due process as it pertains to parents, their rights to their children, to be heard before they're deprived of those rights, it is a common law right that the Constitution secures. Now, why am I going back to these definitions, and why am I stressing that the Constitution understands the due process, the concept of due process in a certain way? Why did the founders understand this in a certain way? Well, often we'll hear that the standards have changed and that there's different considerations, and maybe DCYF needs to be involved and certain statutes need to be enacted because the world has changed, because we have a different understanding of the rights of the parents and how that pertains to the children, and not using a historical analysis method. And to that, I would say that you really need to pay attention to what's going on in the Supreme Court of the United States, as we're seeing a return to the historical analysis method. So in a recent case out of California, Justice Benitez in Fouts versus Bonta says, quote, "The Supreme Court focuses on the original understanding," and this was in a case pertaining to the Second Amendment, specifically actually billy clubs in this case, but the original understanding of the Second Amendment, and thus requires courts to give the greatest weight to evidence from the time period of its adoption. That is because not all history carries the same value. He goes on to say, of the 39 representatives who signed the Constitution in 1787, none were alive 50 years later. James Madison, known as the father of the Constitution, lived the longest, passing away in 1836. This is the most persuasive evidence that the original understanding of the Second Amendment protects a person's right to keep and carry a billy. So, in this case, obviously they're talking about a billy club, but I would really stress to you the importance to see that even the Supreme Court is recognizing that for too long we have used that government agents and officials have used precedent as an excuse to violate the people's rights in error, when the true standard, and again, returning to due process, the true standard must be the historical understanding. And when the founders wrote in our Constitution, the New Hampshire Constitution, in the Bill of Rights, that the people shall not be deprived of their property, of their life, liberty, or estate, and I think we can all agree that children are liberty interests, but by the judgment of their peers, that is very specifically meant to be understood as these people need to go before a jury of their peers, have the right to trial by jury, and for any accuser and anybody who's going to make an accusation to have to swear an oath attesting to the truthfulness of what they say before they can be deprived of their children and of their right to be a parent. You'll see again in Black's Law that really you can summarize due process in this statement, that if any question of fact or liability be conclusively presumed against him, this is not due process of law. Representative Cushman, you're aware of Worcester v. Plymouth, and that it's ripe with references to the right of the people to a trial by jury. And one of the things that are stressed there in that decision is that there is a very important distinction between Part 1 and Part 2 of our state constitution. Part 2, Article 5 gives authority to the general court to make laws, and gives it power to enact certain statutes and such, so long as, quote, the same be not repugnant or contrary to this Constitution. It says that twice, and that's pretty important. I think that they put that there twice because the founders really wanted us to understand that any discussion of rulemaking or statutory authority has to come underneath and follow after the rights of the people, as is reserved to them in Part 1. As far as I'm aware, there is no authority existing anywhere to abridge the rights of the people in Part 1. If you can find that granted to the general court anywhere, and especially the ability for them to grant something which wasn't granted for a body like DCYF to abridge those rights, I'd love to see it. I don't think you're going to find it, though. These are constitutional rights we're talking about. And again, Black's Law will inform us as to what should be understood as a constitutional right, and that is one that is so guaranteed as to prevent legislative interference therewith. I don't think you need to go much further than this. If you can't prove that there is any authority existing within the legislature or any bodies that it creates to take the rights of the people without a trial by jury of their peers who are sworn to the truthfulness of the statements that they're going to make, then you cannot take those rights, and only then can due process occur. Thank you.
Thank you for your testimony. Any questions from members of the committee? Seeing no questions. Thank you.